everybody, I'm so excited. One of the things that we tell people is that investing in commercial real estate is a team contact sport. That means you have to have a team to help you as you're going forward and trying to buy your property, because you don't do it in a vacuum. You need to have lenders, you need to have a whole host of lawyers, accountants, brokers, etc. So our goal is to help introduce you to people who are on our team. And I'm excited to introduce you to somebody that I'm getting ready to hire, and I'll have him come up. His name is Justin, and Justin's going to talk about himself and a little bit about how he came to Nashville and of his background and how he got and started in law. And then I'm going to leave a little bit of a cliffhanger because I want you to figure out what it is he is here to speak on.
Oh, okay. Yeah, so I'm actually born in Nashville. Shortly after parents moved away, ended up in the DC area for middle school, high school, and college, and met a California girl, and she swore to me that all the things I heard about California weren't true. So we moved out to California for law school and practiced out there for about 5 or 6 years. And then after a while, I realized all those things I'd heard about California were true. And so we decided we need to relocate somewhere. So about 5 years ago, moved back to Nashville, and I have a law practice here. It's been doing pretty well in the Franklin area.
So one of the things that I think that is one of the biggest mistakes that people make when it comes to investing in commercial real estate is thinking about the end game. What do you do if something happens to you or to one of the partners in the deal? And what is the plan? That's really an important aspect, because ironically, none of us get out of this life alive. And we might be thinking that we're going to live forever, but what happens if you're in a syndication and one of the general partners passes away? What is your plan? What happens if you have a family member that is involved in your deal and they pass away? Then what is the legacy plan? And how do you set it up so that you can pay the least amount of taxes possible, instead of having to give a bunch of money to Uncle Sam and to the state of Tennessee? So Justin and I talked about that everybody has a plan, whether you know it or not. The state of Tennessee has done one, but maybe it's not going to reflect your wishes. So I want to talk about some of the, first off, talk about law, talk about something I found out new about Justin is that he actually teaches continuing education classes for other lawyers for what he is teaching us today. So I thought that was pretty cool. Also talk about what are your main areas of practice?
Sure. Okay, so you're in the middle of a deal, right? You got a partnership, you're in the middle of a deal, maybe you're going to sell a commercial property, and one of your partners suddenly is either incapacitated or passed away. The question, who has the legal authority to step in for that individual to complete the deal? And so that's an issue that can come up a lot in estate planning. Or maybe it's a family-owned business, and the primary breadwinner or the patriarch of the family has been running that business for all these years, and now they're no longer able to access the bank accounts to pay the bills, to manage that business. Then what do we do? And so what we don't want is to have to rely on the estate plan that the Tennessee legislature has created for you, because the estate plan that the legislature has created may not reflect what you want personally, right? Because estate planning is all about giving what you want to who you want and the way you want it. Having a plan so that the bills continue to be paid, so you're protected if you're incapacitated, that the assets go to the right people. And so that's why we need to clearly document our wishes, be clear that we got decision makers who can step up and handle these things for us. And so a lot of people come in and they've got commercial real estate or they got businesses, and they're like, hey, I need a will. I know I need something. I don't know what I need, but I need something. So we'll come in and we'll talk about wills. And I think a lot of us are familiar with wills. We may have had a family member who's passed away with or without a will, or we watch TV and someone's passed away, and then all the families gathering in the attorney's office, and there's the will reading, right? Or famously, like in the show Dallas back in the 80s, and Joff's will, JR and Bobby had to see who could make the business more profitable and who could make, whoever made the more money, they got the family business. Wills aren't usually like that. There's really, people call me and they say, oh, daddy died, my sister's the executor, when are we gonna have, the will reading? Well, in reality, there's no will reading. But we do need a plan in place so that we can put the right people in place to make those decisions. And so sometimes it is a will, right? Because the will is going to dictate that who's going to receive my property, who's going to administer my estate, and maybe we'll have some cremation or burial instructions in the will and a number of administrative provisions. But the problem with a will or even no will is, what is the process that we have to go through to get that legal authority to make the decisions on this partner of the partnership, or for our parents who may have passed away and they're running a business? Well, it's called probate. Has anyone here ever been through the probate process? You got a hand? Any, just one word, how would you express your feelings about what you had to go through?
Difficult.
Difficult.
Annoying.
So yeah, it can be difficult, can be time consuming. You have to hire an attorney. You have to make sure you have that original will. And then Tennessee is very specific about wills, about how they are constructed, about the execution. People think, oh, I can just go onto the computer, type up a will, print it out, and I get 2 witnesses to sign it and I'm done. And actually, when you have a typewritten will, the requirements that the state of Tennessee imposes are greater than if you had a handwritten will. And so most of my clients who come in, they want to make things as easy as possible. Quick, cheap, transfer the assets on death, save every dollar possible in court costs, attorney's fees, professional fees. And so a lot of times that might mean creating a revocable living trust. Any of you have a living trust? Okay, we've got a couple. All right. So living trust is great because that's the way to just kind of organize all of your affairs, put the people in place who are going to administer your estate for you so that we avoid this court process called probate. One of the other problems with probate is that it opens up your estate to creditor claims. And so I talk, because people come in, they're like, well, I don't know if I need a will or a trust. And I talk to them, well, if we have to go to court and we have to administer your estate, one of the things the court is going to do is publish notice in the newspaper that you've passed away and that your estate is being administered. And what that does is it puts the whole world on notice that they can come forward and file a claim against your estate. And a lot of clients say, well, I pay my bills, I don't have any debts. Well, maybe you do, maybe you don't, but maybe there's a final ambulance bill, final credit card bill, maybe some distant relative says you lent them some money and you never paid it back. And so with living trust, we can retitle those assets from you as an individual to you as the trustee of your trust, so that if you did pass away or you're incapacitated, whoever you choose can step in, manage those assets, collect the rents, pay the bills, and if you've passed away, either sell the assets or distribute them to our beneficiaries. And so when we have clients who come in and they've invested in maybe commercial real estate, single family homes, maybe they've got fractional interests in LLCs or partnerships, we have to make it so that someone can step in and manage their interest in those entities when they've passed away. And so we kind of bridge the gap between that corporate entity and the trust. And so we'll do like an assignment where they take their interest in that entity and move it over to the trust. So if they've passed away, whoever they've named as their successor trustee in that trust can step in, appoint a new manager in the LLC, appoint a new general manager on a partnership, and then things can just continue to proceed like they always have been. Continue to collect the rents, continue to pay the bills, distribute the net income amongst the beneficiaries.
So I know you and I talked about this, about some of the famous things that have happened. So maybe go to the next slide.
Yeah, so maybe we'll go to like slide 4. So the most important thing is to have a plan, right? To clearly document your wishes. Well, some people just forgot to have a plan. So here's just a quick example. We had the Woolsworth fortune, right? So granddaughter of the Woolsworth founder, she inherited the business, age 10 years old. Age 10, she's about the right age to be able to manage a $25 million estate, right? Not susceptible to undue influence. Well, there were no real controls in the trust. She could just have everything once she turned 18. And so she got access. It was about $50 million. actually when she turned 21 in 1933. Well, 46 years, 7 husbands later, she dies with a mere $3,000. How do you go from $50 million to 3,000? So the rate of return on that really wasn't great for her, right? And so they probably would have done well with maybe a corporate trustee or someone who could have managed it better for her. Or we have the next one. We have good old James Dean, right? He was only 29, didn't have a plan, died without a will. And his entire estate, all the licensing fees for the movies, they all passed to his father. But unfortunately, that was the same father who abandoned him. He probably didn't have a relationship with him. If you asked James Dean who he wanted his estate to go to, he probably would say someone other than his father. So again, estate planning is about giving the assets to the people that we want in the manner in which we want. And then we have the beloved Marilyn Monroe, died at age 36. She had a will, so she was the right direction, but she left it all to Lee Strasberg, which was her manager, and he later married. He died. Now his widow gets all of Marilyn's licensing, all of her royalties of her estate. Someone that Marilyn never even knew. I mean, how many of us want to leave our estate to a complete stranger who may not share our values or beliefs or not use the money to support the charities and other causes that we would support? So I just wanted to share those examples to just illustrate the need to have a plan to clearly document our wishes. And so as I mentioned, if I turn on the slides, a lot of people come in, they want a plan in place, they want to make sure they got the decision makers in place, they want to make sure that their kids are going to be protected, that they're going to be protected at incompetency. And so a lot of times we'll do a revocable living trust where the client is still in control. They're still managing all the assets, taking the income, paying the bills. The only problem with the revocable living trust is that because you're the person who creates the trust, you're the grantor, because you're managing it, you're the trustee, you're the beneficiary to use and enjoy. You can amend, revoke, do whatever you want. So the federal government, the IRS, state government, local government, they look through the creator of that trust and see them as still the owner of those assets. Well, that's nice because they have a lot of fixed flexibility and control to change the trust. They don't have to file a separate tax return for the trust. And so it's almost like a disregarded entity. All the income just kind of flows through, but there's no asset protection. So when I have clients come in and they own commercial property or they own, multiple single family dwellings, they're concerned about asset protection. They're concerned about a slip and fall. They're concerned about maybe they sold a property and now they're sitting on a lot of cash. And if they're sued, they don't want those creditors to be able to touch that cash. And so a lot of clients will try to include some sort of asset protection in their overall estate. And when it comes to real estate, the things I think a lot of people think of or they do is to create an LLC, right? Have any of you ever thought about creating an LLC before to create some limitations on liability? Well, what I find in my practice is we'll have people move to the state of Tennessee because they hear about the low tax or they hear there's no state income tax, and their outside advisors will tell them, hey, go create an LLC, protect yourself, protect your outside assets, outside investments. And what they don't realize is that in the state of Tennessee, there is a tax on LLCs called a franchise and excise tax. It's a 6.5% net income tax. It is a 0.25% value tax. And so net income, okay, well, I can take a management fee. I've got a lot of expenses. And so I can kind of push that net income down close to zero. But how do you hide the value on a $6 million building? Or in the example we saw today, possibly a $12 million building. It's hard. And so these individuals who are investing in commercial real estate, they meet with their CPA the following year, and then they get handed this tax bill for tens of thousands of dollars for this LLC. Well, one strategy that we've incorporated for a number of our clients is with the state of Tennessee, you can make a certain election with regard to the LLC. It's called a member obligated entity election. Anyone ever heard of that before? Yeah. So it's great because you're telling the state of Tennessee, hey, I don't want to pay the tax, but in exchange, you're on the hook for all the debts and the liabilities of the company. And people are, well, gosh, why am I going to do that? Well, I created the LLC to provide limited liability. Why am I going to turn around and assume all the liability of this entity? So a lot of times what we'll do is we'll take that ownership interest in the LLC, it's called a membership interest, and we'll throw it into an asset protection trust so that they've avoided having to pay the tax, but then at the same time, they still have the asset protection. I have a client right now I'm working with. He and his father bought a building, I believe it was on 2nd Avenue, just down from Wild Horse Saloon. Bought it $36 million, now worth about $50 million. And we sat down with the CPA and looked at their return, and he paid $80,000 last year in franchise and excise tax. And boy, was he upset when he realized that his CPA never told him that there was an option to avoid the tax. And so we're working on a plan for him to be able to save him that $80,000 a year. So think about all the ways that you could take $80,000 and reinvest it, or do charitable gifts, or gifts for children or grandchildren, or just improve your quality of life. So that's a common strategy. But with this asset protection trust in the state of Tennessee, it's what's called a Tennessee Investment Services Trust, where you can kind of have your cake and eat it too. You can take assets, put it in this special type of trust, still receive the income, still be able to access the principal. And as long as you comply with the statute, future creditors cannot attach that asset. And so maybe it's not a commercial building. Maybe you're just sitting on some cash and you want to protect it, and you can put it in one of those types of trusts called the Tennessee Investment Services Trust. Or sometimes, we'll have people who have sold a business and now they've got that cash and they want to protect it. But there are some things that you have to comply with. First, it's an irrevocable trust. And so people are like, well, gosh, I don't know that I want to create an irrevocable trust. I may want to change it. But we can structure the trust in a way that you could still change your trustee. Now, because it's irrevocable, you can't do an amendment like you would on a typical revocable living trust, but you do have what's called a power of appointment, where you can reserve this power of appointment. So let's say you created this trust in 2023, and now you get to 2025, and you're like, well, when I set up that trust, I said that it was going to go equally to my 3 kids if I pass away, but now my 1 child is not talking to me anymore, and I want to bypass them and just have it go to your grandkids. So you can do what's called an exercise of a power of appointment, where you can say, okay, with respect to that trust I created in 2023, now I want to change the beneficiaries to be these separate individuals, and then you can modify who the ultimate beneficiaries are as well. And we can structure that trust as a disregarded entity, make it tax neutral, so that all the tax is still reported on your personal return, but for asset protection purposes, it's as if you no longer own the property. And so that's the whole idea with asset protection, is being able to separate kind of the title or the ownership of the property from the economic benefits, right? Because if you're sued or you go through bankruptcy, they're going to try and collect anything that's in your name, but they can't attach those things that are not in your name. And so that's where these asset protection trusts, where LLCs can come into play, where you can still receive those benefits, even though it's not technically in your name. Another key asset protection strategy in Tennessee is, most married couples, when they buy a piece of real property, if they're not putting it in a trust, they're going to take title by tenants by the entirety. And so you may have seen it. You take title, it says, John Smith and wife, Mary Smith. That is by default tenants by the entirety. So maybe the husband ends up in a lawsuit, ends up in bankruptcy, because that property is tenants by the entirety. The bankruptcy trustee or the creditors cannot attach that property. But then you say, well, gosh, yeah, tenants by the entirety is great, but what about an estate plan? What about putting it in a trust where I can dictate how that asset is going to be managed if I pass away? Who my beneficiaries are going to be? Who is going to manage this commercial piece of property over the years? And so thankfully, the legislature got wise to this problem. And so they created what's called a tenants by the entirety trust, where essentially you say in the trust, hey, I'm transferring this property to the trust, but for all intents and purposes, it's still tenants by the entirety. And so it's still protected from bankruptcy, still protected from lawsuits or creditors of one spouse.